The U.S. Supreme Court is going to do oral arguments on birthright citizenships May the 15th. People who were born in the U.S. but do not come from American citizens are going to be at risk for deportation, y'all. If you came here from another country and your children were born here, they will no longer be considered American citizens. If the U.S. Supreme Court rules in favor of this being upheld, we are in dire, dire trouble. As you know, the U.S. Supreme Court ruled 9-0 to bring back Kilmar Garcia to the United States, but he did not listen to their order. If you were born outside of the United States and you have children here, they will lose their citizenship. This is not a drill. This is not a joke. This is serious, and it needs to be taken seriously. If you have been here your whole entire life and your parents were born outside of the United States, this is you. This is your citizenship that is at jeopardy. May 15th. That's D-Day.
Moments ago, the Supreme Court agreed to hear Donald Trump's birthright citizenship arguments, where he suggests that birthright citizenship is not actually within the Constitution. They're going to hear that on May 15th, and they expect results, a ruling by late June, early July.
President Trump wants to end birthright citizenship, and the Supreme Court has scheduled a special session to hear the case next month. Lower courts have blocked the president's order, ruling that it violates the 14th Amendment. But the case before the justices on May 15 is not expected to focus on birthright citizenship, but on whether judges have the authority to block the president's initiatives like birthright citizenship nationwide.
The Trump administration is trying to get the Supreme Court to weigh in on his executive order on birthright citizenship.
So there are 3 different courts already that have enjoined that birthright citizenship executive order as unconstitutional. And the appeals courts in each of those areas of the country have upheld those determinations. What the Trump administration is trying to do now is essentially provoke what's called a circuit split. They want the court to say it's untenable for a single district court to impose a nationwide injunction. Why do they want that? Because if they get the court to say that you can't do that, then theoretically the plaintiffs have to go to other places in the country that are less favorable for them, try to enjoin this birthright citizenship ruling. They will likely lose in one of those places, which will allow the administration to implement it in those places, but more importantly, set up a dispute between 2 federal appeals courts. And that's how you get to the Supreme Court, my friend.
They don't have a path to do that without this request?
I mean, they do in the sense that there are already 3 adverse rulings. But usually if you're trying to game out how to get the Supreme Court to take your case, one of the surest ways to get the Supreme Court to intervene is to show them 2 federal appeals courts disagree on something fundamental, including whether or not this can apply across the country.
Time ago, the Supreme Court agreed to hear oral arguments in the case about ending birthright citizenship. How confident are you that the court will rule in your favor and allow that order to end birthright citizenship to go forward?
Well, you're just telling me that for the first time. I am so happy. I think the case has been so misunderstood. That case, birthright citizenship, is about slavery. If you look at the details of it, the signings of it, everything else, that case is all about slavery. And if you view it from that standpoint, people understand it. But for some reason, lawyers don't talk about it. The news doesn't talk about it. That's not about tourists coming in and touching a piece of sand and all of a sudden they're a citizenship. They're a citizen. That is all about slavery. And even look at the dates on which it was signed. It was right at that era, right after the Civil War. And if you look at it that way, the case is an easy case to win. And I hope the lawyers talk about birthright, citizenship, and slavery, because that's what it was all about. And it was it was meant to be positive. And they use it now instead, not for slavery, they use it for people that come into our country and they walk in and all of a sudden they become citizens and they pay a lot of money to different cartels and others. It's all about slavery, and if you look at it that way, we should win that case.
Trump claims that birthright citizenship is only about slavery. Listen.
The case is an easy case to win. And I hope the lawyers talk about birthright, citizenship, and slavery, because that's what it was all about. And it was a very positive, it was meant to be positive. And they use it now instead, not for slavery, they use it for people that come into our country and they walk in and all of a sudden they become citizens and they pay a lot of money to different cartels and others.
He's not giving you the full story, though. Yes, the 14th Amendment was created after the Civil War. It was created to make sure that formerly enslaved people were recognized as U.S. citizens, and super important moment in history. But over time, the 14th Amendment has evolved. Courts have ruled repeatedly that if you're born in the U.S., you're a citizen no matter where your parents came from. It's called jus soli, or the right to the soil, meaning you are given citizenship if you're born to the state of that territory. A Supreme Court case in 1898 confirmed this, that it applies to everyone and not just children of formerly enslaved people. So when you hear politicians say it's only about slavery, they're ignoring over a century of legal evolution. The Constitution isn't stuck in the past. It's meant to grow with us, but it is not meant to be violated.
The United States Supreme Court has agreed to weigh in on the Trump administration's efforts to end birthright citizenship. Birthright citizenship allows nearly everyone born on U.S. soil to be a citizen of the United States, regardless of the legal status of the parents, and it's been around a long time. The 14th Amendment was ratified after the Civil War, and it says all persons born or naturalized in the United States and subject to the jurisdiction thereof, which is part of the debate, are citizens of the United States and the state wherein they reside. And in 1898, the Supreme Court clarified in a case called Wong Kim Ark that birthright citizenship is broad and applies to nearly everyone born on United States soil. 3 separate district court judges paused the Trump administration's efforts to end birthright citizenship with nationwide injunctions. And today, the Supreme Court declined to lift those nationwide injunctions while they consider the case. DOJ had asked the Supreme Court to lift the nationwide injunctions and just have them applied to the people who were before the court in those specific cases. This is part of the broader debate we're having about nationwide injunctions and the power of a single federal district court judge to issue a nationwide injunction that applies well beyond the parties before him or her or in that jurisdiction specifically. And it almost certainly will be coming up at oral argument, which is set for May 15th at 10 a.m. It is rare for the Supreme Court to set a May argument, but here we go. Drop your questions in the comments.